All right, good evening, folks. Welcome to Monday Night Law, Kirk's Law Corner. How's everybody doing tonight? Good times. Went camping. It was a very good time. Get away, relax a little bit, do some dirt bike riding, get up in the mountains. It's a little bit smoky up there, but we made it through. Oops. Sorry about that. No sound out there on Telegram. So tonight, we're going to go over the right to throw off a despotic government and kind of a gist of the process, due process of law. Everything must follow the process that is due. Many people do not quite comprehend that, but there is a process. Due process of law. You know, kind of can even see it in the Bill of Rights. The First Amendment. The right to peaceably assemble. The right to petition the government for the redress of grievances. Then the second. Why is the first and the second the second? Because that's part of due process of law. The law dictates the process. Nope, didn't do any fishing. Played around in the water, though. Definitely, when it got hot, we went down to the water and took a swim. Cooled off. Hottest part of the days up there. But, no, just camping and dirt biking. Just having a good old time. Dirt biking in the morning, early-ish, until it gets hot, and then come back, relax, and chase the shade. And follow the water. So it was good. It still was really, really, really good. It was pretty warm during the day, but it's hot right now here locally. I mean, crap, I think we're at 105 right now. 105, 106. 107. Yeah, she's warm. AC working overtime today. And yesterday, it was, man, when I got back from camping, it was 107. So, yeah, about the same as yesterday. Alright, so, let's see. Let's go over here to the comments. Uh, Walter Douglas, I hear on Telegram, could you give an explanation for continuity of government? When do we institute it? It's already done. It's been happening since 2016. Again, we're under martial law. A lot of people don't understand that we're under martial law. That continuity of government, people understand what is a continuity of government. I've explained this before several times now. It's a continuation of government because certain parts of government can't fail. Okay? So this is a continuity, a continuation of government because the old government is being taken down. The corruption, those involved in serious human rights abuse and corruption worldwide. Okay? But we have a continuity of government here for America to perpetuate government pending the outcome of the war. This is Texas v. White. The president only acting as commander-in-chief. There is no president right now, folks. We have a commander-in-chief, and that is Donald J. Trump. Whether people like that or not, that's the law. That's how that works. So we have a continuation of government, the basics, necessities to maintain law and order, which is done by who? Oh, the military. That's where we're at. That's what's happening. Has been happening. Okay, Executive Order 13818. Blocking the property of those involved in serious human rights abuse and corruption worldwide. Taking down bad governmental regimes, instituting new government, holding elections, and doing a treaty of peace. That's what's been happening since December 20th, 2017. That's a fact. I've shown it. I've proved it. I don't know what else people need out there to fully comprehend what this means by a continuity of government. And that we are, in fact, at a world war. This is a revolutionary war. Why do you think Trump did the 1776 Commission? 1776. Okay? Revolution. Revolutionary. War. So hopefully that explains that in the short. Well, can argue all you want. Go get the 2 federal directives, which I've posted on Telegram, and read them. So you can fully comprehend what they meant by the 2 federal directives for continuity of government. Oh, let's look at you. Okay. No. Kamala Harris, no. Remember, Trump did not concede the election. Not only that, Trump did the involuntary bankruptcy as president. You know, the president of the corporation, United States Inc., did the involuntary bankruptcy on the corporation. June of 2020. Therefore, that corporation is done and there is no president, only a commander-in-chief. Now, the fake election that we had was Trump did not concede the election, period. Trump didn't turn over any key codes or nuclear codes or any of that. No transfer of power, none, zero. And I've explained this before. The incumbent is supposed to do a writ of quo warranto. By what authority does so-and-so still hold that office? Again, due process of law. The law dictates this process. It doesn't just arbitrarily happen. You've got to follow due process of law, and that didn't happen. Not only that, it's pretty difficult for that so-called man, Joseph R. Biden, to be the so-called president when he was arrested, taken off to Gitmo through a military tribunal, and executed and buried in Arlington Cemetery in 2018. Just exactly how is Joseph R. Biden the president of the United States Inc. Corporation? When there isn't a corporation anymore, it's defunct, it's bankrupt, it's done, it's over. It doesn't exist anymore. And he's already executed and buried in 2018. Come on, people, wake up. What the hell? Check it out now, Mike, over on Rumble, because I've got comments coming in on the live chat now. I don't know if maybe I didn't have it pulled up until just now, so I don't know. No. I don't know who you think you are over here on Telegram Mythical Truths. You're so full of shit, but that's okay. Trump didn't give the power to FEMA, and everyone is being a U.S. citizen. There's no such thing as a U.S. citizen. Okay? Again, people don't read. It just boggles my mind. People think they know what they're talking about, and they just don't, and it shows. Let's look at the Constitution under Article 4. Citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Wait, citizens of each state, not a citizen of the United States, and there's no such thing as U.S. citizen. Now, 14th Amendment specifically states citizen of the United States, still not U.S. citizen. Okay? But again, what is a citizen? Again, reading means reading. Oh, yeah, I don't have that one pulled up right this second. I'll have to take a look-see here. I have the Law of Nations. No, not in that. Where are you? We've been right here. I thought I moved it. Come on. IGKL? Who the hell are you? Damn it, Jim. Maybe I did move it. Oh, there it is. Oh, wait, here we go. There it is. Law of Nations, Book 1, Chapter 19, Subsection 212. This is definition. Citizens and natives. The citizens are the members of a civil society bound to this society by certain duties. Members and bound. Certain duties and subject to its authority. They equally participate in its advantages. Those emoluments, any advantage, profit, or gain received due to one's position of employment or holding of office. Oh. Wait a minute. Again. Members of a civil society. Civil society is government. Bound to this society, bound to the government, by certain duties you have to perform. And subject to its authority. Okay, and they receive the advantages. Now let's take a look at that. In Article 6, Clause 3. It's funny how our founders wrote directly from the Law of Nations. The senators and representatives before mentioned and the members of the several state legislatures and all executive and judicial officers. So, in other words, every member, everyone from the legislative, executive, and judicial are members. Okay? Both of the United States and of the several states shall be bound by oath or affirmation to what? To support this Constitution. If you're not a member of the legislative, executive, or judicial branch, either state or federal, you're not bound by the Constitution, and you're not subject to its authority. This should make just plain, simple, common sense. Now, what we are is inhabitants, or the people. Not American state nationals, not all that fraud garbage. Okay? Now, when we read, because reading means reading, under Section 213. See, this is law of nations, regarded as international law. So, inhabitants, the inhabitants, as distinguished from citizens, are foreigners. That's right, we're foreign to the Constitution. We're not part of that legal society. Who are permitted to settle and stay in the country. Country? Oh, that's right. The nation is called America. What we call states are actually countries. You know, they have their own flag, they have their own constitution. Nation states, or countries, make up the nation. Bound to this society by their residence, they are subject to the laws of the state while they reside in it, and they are obliged to defend it because it grants them protection, though they do not participate in all the rights of citizens. They enjoy only the advantages which the law or custom gives them. The perpetual habitants, now pay attention here, are those who have received the right of perpetual residence. These are a kind of citizens of an inferior order. We call those the people. Now remember, we have the right to create our own form of government. And in our republican form of government, the citizens are the public servants. We, the people, are the inhabitants or inferior citizens. But we are superior in power because that's what a republic is. At least our Confederate Republic. Okay? All political power is vested in the people. Again, not American state nationals. It's a fraud. It's people. Okay? That's what we're talking about. Perpetual habitants. Ones that have declared that they are settling here. That they are residents. And I know a lot of people do not like that because they go off of the code and their definitions over there through the Roman civil law, the code. Forget the code, read law of nations. And are united to the society without participating in all its advantages. Their children follow the condition of their fathers. Imagine that. Law dictates that the children follow the conditions of the fathers. And as the state has given to these the right of perpetual residence, their right passes to their posterity. So, here's real law. As it is written. Not my opinion, but rather facts of law. And we'll go with the question I've had several times. Well, what makes you think the law of nations applies here in America? Well, because it's the law of nations. And it is regarded as international law. But some will say, oh, whatever, it doesn't da-da-da-da. Well, how about we just read from the Constitution, Article 1, Section 8. Let's see. Right here. To define and punish piracies and felonies committed on the high seas, and offenses against the law of nations. Oh. But we don't go by the law of nations. Yes, we do. It's right there in the Constitution. The supreme law of the land. It's right there. Have you read it? Do you fully comprehend and understand what it means by and offenses against the law of nations? What other law of nations would we be talking about? Or would they be talking about? The Law of Nations, written by Emer D. Vattel. That's right. Now, what about throwing off despotic governments? Well, let's just read this Declaration of Independence. Laying down the law, because that's what a declaration does. It lays down the law. When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them. It's not natural law, it's laws of nature. It's a body of law. and of nature's God entitle them. And notice it's people, not nationals. A decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. See, this is declaring the causes for the separation. Why did we separate from Great Britain? Or would that be that Lee's resolution? That'd be this one. June 7th, 1776. Resolution introduced to the Continental Congress by Richard Henry Lee, Virginia, proposing a Declaration of Independence, June 7th, 1776. Resolved that these United Colonies are and have right to be free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved. That it is expedient forthwith to take the most effectual measures for forming foreign alliances, that a plan of confederation be prepared and transmitted to the respective colonies for their consideration and approbation. What's the source on that? Documents illustrated the formation of the Union of the American States. Union. That's the Confederacy. That's right. That's why we are a Confederate Republic. And again, right in the preamble of the Constitution, what does it say? As it is written, we the people of the United States, in order to form a more perfect union. Does that mean we already had a perfect union before? This is just to create a more perfect union. A confederation. It's in one of these books over here, Montesquieu's Spirit of Laws. It goes over about the Confederate Republic. So, again, documents illustrated the formation of the Union of American States. That's actually this book over here, buried in a couple of other books. And I have the PDF on it as well. So, facts are facts. Being presented with these facts, do you change your mind? Are you of sound mind? Do you possess logic and reason? Are you capable of coming to a reasonable conclusion based in reality? Or are you insane? Because these are the facts of law, of history of law, as it is written. Again, not my opinion. These are facts. Here's the evidence to support the claim that this is the truth. Okay. Now, back to these causes for the separation. We hold these truths to be self-evident. That all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and pursuit of happiness. That, to secure these rights, governments are instituted among men. What does that mean? Of the people, by the people, for the people. That's our republic. Deriving their just powers from the consent of the governed. How do they get their just powers? from the Constitution. Because, see, in the preamble, this is a preemption. We, the people, establish justice. We, the people, ensure domestic tranquility. We, the people, provide for the common defense. We, the people, promote the general welfare. We, the people, secure the blessings of liberty to ourselves and our posterity. We, the people, do ordain and establish this Constitution for the United States of America. This is done by the people. And this is the power retained by the people in the preamble, a preemption. What they say here, the preamble to the Constitution, an introductory statement of the principles at work in the full text. It is referred to in countless speeches, judicial opinions, and in a song from Schoolhouse Rock. Courts will not interpret the preamble to confer any rights or powers not granted specifically in the Constitution. Well, imagine that. Because the preamble is a preemption. This is saying these are powers reserved by the people. The people are establishing justice. The people ensure domestic tranquility. We do this of the people, by the people, for the people. Not of the corporation, the crown, by the corporation for the crown, and for the corporation. No. You gotta comprehend this. Who has what power and who does not? And how are those powers delegated or granted? Deriving their just powers from the Constitution. Just like when we look at Article 1, Section 8. What does it say? Scope of legislative power. Here are the powers delegated. The Congress shall have power to lay and collect taxes, duties, imposts, and excise, to pay the debts and provide for the common defense and general welfare of the United States, to provide for. We, the people, provide for the common defense and the general welfare. This is the money, right? But all duties, imposts, and excise shall be uniform throughout the United States. To borrow money on the credit of the United States, to regulate commerce with foreign nations and among the several states. So it's to regulate commerce with foreign nations in the states, to regulate commerce with foreign nations and the Indian tribes. Federalist 45 doesn't talk about interstate commerce. It talks about foreign commerce. This particular clause right here. And the resolution introduced by Virginia for this particular thing to amend the Articles of Confederation was specific to regulating foreign commerce. That's it. Okay? So, again, as it is written, facts of law. Here's the powers delegated. To constitute tribunals inferior to the Supreme Court. To define and punish piracies, values committed on the high seas, and offenses against the laws of nations. To declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. For war. To raise and support armies, but no appropriation of money to that use shall be for longer than a term than 2 years. Now, here's the thing. Why in the heck do they declare war on this, war on that every 2 years? because of that clause right there. That's why. Because we're under martial law, war. We're at war. Have been essentially even since 1776. Okay? Oh, I get this all the time. I need a constitutional lawyer to protect my grandchildren in Texas. They're in the grass of CPA. No, what you need to do is study and learn the law for yourself. There's no such thing as a constitutional lawyer. That doesn't lawfully exist. It's fraud. Ignorance of the law is no excuse. We're supposed to know the law. It's up to us to defend ourselves. Which is partly why I'm here, trying to educate my fellow man on what the law is, what your rights are, where do they come from, how to effectively claim, exercise, and defend them following due process of law. Here's my analogy here is you're out in the middle of the lake and you don't know how to swim and you're yelling to somebody on the shore for help. There's no help. You're going to drown because you don't know the law. There's nothing anybody can do on shore to help you from drowning. You're too far out, can't get to you. That's just reality. I'm sorry about your situation that you're in, but this is what we're dealing with. Corruption. Serious human rights abuse and corruption. Ignorance of the law is no excuse, folks. There is no excuse. None. Zero. And I've heard them all. Trust me, by this particular point in time, after been doing this for, since 2017, 7 years of doing lives, that doesn't count all the years I've been studying on my own since 1995. Listening to all the excuses about how come I don't know. Well, I just can't. Spending 6 months with somebody on a regular basis trying to educate them, they just can't do it. Blows my mind. Right? Absolutely, Mark. My brother Mark out here on YouTube. Even their own code says that the people have all the power. We are the masters. For Idaho, it's Title 74, subsection 201. The people, in creating the instruments of government that serve them. Serve. We're the masters, they're the servants. Do not yield their sovereignty to the agency so created. And I like Washington's. It goes further and says it's not up to them to tell us what we need to know. It's not their job. It's not their duty. That's not what government was instituted for. It was government, fundamentally and principally, was instituted what? To secure these rights from infringement. That is the original intent of creating government. And when government does not live up to the original intent, it no longer has the authority to exist. It is unlawful. It is despotic. It is tyranny. Now, let's get into the meaty part here. That whenever any form of government becomes destructive of these ends, securing these rights, exceeding their just powers, It is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form, like a republican form of government, as to them shall seem most likely to affect their safety and happiness. Now, here it is again. Prudence indeed will dictate that governments long established should not be changed for light and transient causes. And accordingly, all experience hath shown that mankind are more disposed to suffer, while evils are sufferable, than to right themselves by abolishing the forms to which they are accustomed. This is where we're at, folks. People are more disposed to suffer, while evils are sufferable, than to right themselves by abolishing the forms to which they are accustomed. People have gotten accustomed to serious human rights abuse and corruption. When are the people going to stand up? When are you going to learn? I mean, what are you waiting for? Are you waiting for somebody else to do it? Because that's not how that works. It's the people that have to do it. If you're waiting for Donald J. Trump to do this for you, that's a misnomer. No. All political power is in the people. We have the right to alter, reform, or abolish anything at any time we deem it necessary. This has to be done by the people. Not anybody else. Not a king. There's no kings here. Not in our republic. That's a monarchy that does kings. But when a long train of abuses and usurpations pursue invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security. What does the Second Amendment say again? A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Well, the well-regulated militia, that's the military, both state and federal. That's the well-regulated. You see, Congress has the authority to regulate the militia. But that's the organized by state or organized by federal. But when it comes to the unorganized portion by government, we didn't delegate that power. That's what the second part of the Second Amendment is, the right of the people. Because, I don't know. Maybe we should look at the very first declaration in our new nation called America, the Virginia Declaration of Rights. Should have been right here. Where is it? Did I miss it? Oh, there it is. Here's a very good part. The government is or ought to be instituted for the common benefit, protection, and security of the people, nation, or community. Of all the various modes and forms of government, that is best, which is capable of producing the greatest degree of happiness and safety, and is most effectually secured against the danger of maladministration. And that whenever any government shall be found inadequate or contrary to these purposes, a majority of the community hath an indubitable, unalienable, and indefeasible right to reform, alter, or abolish it in such manner as shall be judged most conducive to the public weal. Now this is a key part here. That all power is vested in and constantly derived from the people. Again, where does it say national? Doesn't exist. That magistrates are their trustees and servants, and at all times, amenable to them, to the people. Now this is key to part of due process of law, which we'll read here shortly. Let's see. That a well-regulated militia, composed of the body of the people, trained to arms, is the proper, natural, and safe defense of a free state. Wait a minute. Let's read that Second Amendment again. A well-regulated militia be necessary to the security of a free state. Doesn't that sound exactly like that? That a well-regulated militia composed of the body of the people, trained to arms, is the proper, natural, and safe defense of a free state? That standing armies in time of peace should be avoided as dangerous to liberty, and that in all cases the military should be under strict subordination to and be governed by the civil power. That no free government or the blessings of liberty can be preserved to any people but by a firm adherence to justice, moderation, temperance, frugality, and virtue, morals, principles, and by frequent reoccurrence to fundamental principles. That's what we're doing here tonight. We're having a reoccurrence to fundamental principles. Who has what power here? Fundamentally and principally. We do. The people have all the power. All of it. Not the president, not Trump, not anybody else. The people have the power. They're the servants. They have to do what we tell them to do. Even the military does. They are all servants of the people. Plain and simple. And for those that like to say that, oh no, we're not a Christian nation. Oh really? That religion or the duty which we owe to our Creator and the manner of discharging it can be directed by reason and conviction, not by force or violence, and therefore all men are equally entitled to the free exercise of religion according to the dictates of conscience, and that it is the mutual duty of all to practice Christian forbearance, love, and charity towards each other. There you have it. In writing, as it is written, as the first document declaring Christianity as our religion for the new nation called America. This is June 12th. Again, this is episode 1 of my educational series. June 7th. June 12th. Again, June 7th, we do the separation. June 12th, we declare, we lay down the law, Declaration of Rights, or law. Then the Virginia Constitution, June 29th, which Avalon doesn't show. They do not like to show the Virginia Constitution because it lays out our three distinct branches of government in our republic, this nation called America. And many people do not comprehend that Virginia, why is it Virginia? Because Virginia was a very large territorial mass. And Virginia started in 1606 with the first charter of Virginia, 1609 with the second, 1611, 1612 with the third. Then the Mayflower Compact, which actually, again, settling in the northern parts of Virginia, as it is written, and then the Ordinance of Virginia of 1621. That's the government, establishing a government. Oh, Red Bobby out on YouTube. Well, I disagree. Thinks that this is not useful, in fact, but it's comfortable. No, it's very useful because it's knowledge. Knowledge is power. If you don't have this knowledge, you have no power. Because reading means reading. Oh, it's so boring. That's where they get us. But if it's so boring, why are you here? You know, the thing is, folks, I get it. That reading, especially reading law, can be boring. With today's entertainment out there, at your fingertips with your phone and computers and video games and, TV, all that stuff wasn't around back then. Gee, what do you think that's about? Distraction. It's the same shit over again. It's just with technology now. So, I hated to read in school. I really did. But there's something that has fascinated me with the law, and for good reason. Because knowledge is power, and without this knowledge, we have no power. And this is the problem we have in our society or world today, is because people would much rather what? That mankind is more disposed to suffer while evils are sufferable than to right themselves by abolishing the forms to which they are accustomed. Well, how in the heck are you going to abolish the forms when you don't know the frickin' law? When you don't know due process of law? Because you've never read it. Because it's so boring. That's what they're talking about. Rather than educate yourself and stand up and follow due process of law, they'd rather sit around and bitch and complain about how boring it is. And, well, I just would, I'd rather watch my football game. I'd rather watch my favorite basketball team, baseball team, play sports. Or I'd rather play around on my phone and watch videos or... there's just so many distractions out there. That's the problem. That's a good one. Red Bobby, YouTube. I'm here to see how not to be effective. You are not effective. Really? Huh. Just had another one today. Got it in the mail. Case dismissed. Imagine that. Right from the get-go. Notice of special appearance objecting to the personal jurisdiction. Motion to dismiss. Case dismissed. Oh. Yeah, we just filed this last week. Huh. Clearly, I'm not effective. Nip that one right in the butt, right from the get-go. Gotta love the trolls out here. I love it. Because then I get to bring things up. Like winning. Because winning is good. Right? Who doesn't like to win? Huh. And this is one of my local people. Right? Happened again. Winning. Gotta love it. Following due process of law, rules of procedure, all those things we're supposed to do to be effective. To effectively claim, exercise, and defend those rights following due process of law. Wonder how much Red Bobby knows about due process of law and rules of procedure. Wonder how effective they have been. And if you're so effective, then why are you here? Are you trolling? You just a troll? Because that's what trolls do, right? No. See, I don't have clients like that. I don't represent people in court. I provide education. And no, they didn't go to jail. Nobody's gone to jail. No. That's a lie. You're a liar. Nope. Oh, you mean Casey Baker, which that case was actually dismissed after review, right? But see, they stopped coming to me. They stopped learning. Oh, but you don't want to tell the whole truth. And no, Casey didn't go to jail. They dismissed the case. See, again, you're a troll, not telling the whole truth. Yep, Red Bobby's a troll. Another one of those ones who thinks he knows what he's talking about when he doesn't. So where's your evidence to support your claim there, Red Bobby? Right? Out here on Rumble. Poodle Pearl. Trans-rigged sports. Unbelievable how dumbed down people are, spending hours of their lives watching grown adults throw balls. That's it. But again, back to the Declaration of Independence. Remember, it's not just our right, it's our duty. But mankind are more disposed to suffer. Casey, right there. They quit coming to me, they quit learning. and they couldn't articulate the original paperwork. This is the same problem Tony Pellegrino and I both have, as we try to educate these people and help them do the paperwork, and then when it comes time to go to court and articulate, they can't. So whose problem is that? It's not me. Clearly, just had another case. Just one. Case dismissed. What's the difference? Somebody who knows and somebody who doesn't. I've won several of my last several cases. Now this particular one right now, oh, this is a good one though. So we'll see what happens with this one. Went through two trials. Yeah. No. Tell the whole truth, Red Bobby. The case was dismissed. You're a liar. And yes, I went in to try, but it was, see, you don't get it. It was a setup for them. For my standing for a cause of action, for the right to the assistance of counsel, which we all have that right. And yeah, I spent a couple days in jail for contempt of court, which gives me standing to a right to a cause of action, does it not? I mean, that's what we're talking about here tonight. Maladministration. Serious human rights abuse and corruption. Well, how about you show us the paperwork, Red Bobby? Sorry. How about you show us? You're the one making all these accusations and claims. Where's your evidence to support your claims? But I could. But let's not get distracted with Red Bobby. Let's get back to what we need to do. What is it we need to do, people? Do you want to sit here and be disposed to suffer? Or would you rather right yourself and abolish the forms to which we're accustomed? Well, you know. What do you want to do, people? I mean, it's up to us. All the power is inherent in the people. And all we have to do is follow due process of law. First of all, we need to reassemble the people. All political power is inherent in the people. That's what we talk about over there on the National Assembly. Right? I mean, that's how that works. We have to reassemble the people. I mean, if we do not reassemble the people, how are we going to do anything? I mean, that's just how that works. Bye, Red Bobby. See how we do that? We just make it real simple. We just get rid of you. We've had enough of you. No more comments from Red Bobby. Uh-oh. Sucks to be Red Bobby. So, what are we going to do, people? Well, it's not the General Assembly. See, the General Assembly is the legislative branch. We need to reassemble government de jure, the people, which comes before the General Assembly. So this is where we're at, folks. It has to be of the people, by the people, for the people. But it has to be done by the people. No assembly. Now they call it the General Jural Assembly. But again, it's just assembling the people. Peaceably assemble. The General Assembly is the legislative branch. Well, how do you have a legislative branch of government without the people? Because the legislative branch comes from the Constitution. So let's think about building this thing. It's like building a house, building an engine. Okay? But you don't have a house, literally a house, which is composed of the representatives and senators. Okay? You can't have a house without the bedrock, the foundation, and the framework. The framework is a frame of government, which comes from the Constitution. So you have to have the bedrock first, then you have to have the foundation, then you can start building. And then when the house is completed, then you have the Constitution. Then you have government. What we need to do is the common law side of our republic. The people, following the common law, the law of nations, things like that. We have that power. So it's up to us to do this. Now, I want to go back through the Declaration of Independence here. Go back down here to the bottom part. In every stage of these oppressions, we have what? Petitioned for redress in the most humble terms. All right, folks. Where are the petitions? Okay? Where are they? Where are the petitions? First Amendment. Now, this is where we're going to get into Blackstone's commentaries on the law of England. Let's see if I can find this again. Because it talks about vindication of these rights. So, of the Parliament, this is Book 1, Chapter 2, Section 146. We are next to treat of the rights and duties of persons as they are members of society and stand in various relations to each other. These relations are either public or private. We will first consider those that are public. The most universal public relation by which men are connected together is that of government, namely as governors and governed, or in other words, as magistrates and people. Of magistrates, some are supreme, in whom the sovereign power of the state resides. Others are subordinate, deriving all their authority from the supreme magistrate, accountable to him for their conduct and acting in an inferior secondary sphere. This is why Congress has the authority to create inferior courts to the Supreme Court. But they have to stay within the limitation of the original intent of creating the judicial branch and vesting judicial power under admiralty and maritime jurisdiction. Because that's what it says in Article 3. Section 2. Admiralty and maritime jurisdiction. That's it. Doesn't say any other jurisdiction there. So none of the inferior courts can exceed that jurisdiction. Now, let me blow this up because I'm sure it's a little bit hard to see out there. In all tyrannical governments, the supreme magistrate or the right both of making and enforcing the laws is vested in one and the same man or one and the same body of men. And wherever these two powers are united together, there can be no public liberty. Imagine that. That's a tyrannical government. This is why the people, when they created our form of government that was retained by the people, our common law grand juries. Mark Bond, brother, John Gentry tried a redress and was denied. Because John Gentry doesn't want to listen either. It's not a remonstrance. It's a petition. There is a difference. And way back when, he was told that it was a whale. This is why we split up, because he wouldn't listen. And now that I've discovered Lex Parliamentary Americana, who lays out the actual elements of a petition, the proper format of a petition, is very short, clear, and concise. So again, reading means reading. Knowledge is power. We have to learn how to do this. So refusing to learn is the downfall. Lack of knowledge. My people will perish for lack of knowledge. Hello? Let's read, comprehend, then understand, and then take the action. But again, the state legislature isn't the end-all be-all, right? If you petition the state legislature, what's the next one? Wouldn't that be federal legislature? I think it would be. This is where you get into Article 4, Section 4, right? This is that domestic violence, internal insurrection. Now, I want to tell you right now how we all got started here with Chris Hallett and that stuff with a petition to Congress, even though not even in the proper form of a petition, to be honest. But this is how things got rolling down there in Ector County, Texas, for one man. The entire Magistrate Division of Family Court was abolished bulk transfer of over 1,250 cases to the district court, scheduled for dismissal. That was done in February of 2018, scheduled for dismissal December of 2018. So don't tell me that petitioning the legislative branch doesn't work, because it does. And it has. Again, excuses. They're like assholes. Everybody's got one and they all stink. And the most common one, well, my legislature is corrupt. So that's stopping you from claiming and exercising your right to petition the legislature for the redress of grievances? That's the right. The right dictates this process. That's tyrannical when they deny the right. So, we have to do this, right? We cannot, there is no member of the bar out there that's going to do this. They don't even know jack shit about doing petitions to the legislature for the redress of grievances. Oh, they went to law school, all right. They learned their code. Roman civil law. Code pleadings. No. I'm not here to practice Roman civil law. I don't want to be a member of the bar holding that title of nobility of Esquire. No, thank you. Thought about it, contemplated it many years ago. Didn't do it. Well, good question. Third eye knowledge here on YouTube. So when they deny, what's the next step? Well, how about do the first step and then come talk to me? Do it. But again, you got to have the knowledge. And like I've showed people, okay, even in Mason's Manual Legislative Procedure, Lex Parliamentary Americana, elements of the law and practice of the legislative assemblies in the United States of America, says that petitioners have the right to present their own petition. You have to know this. You have to be able to present this when they say, oh, well, no, you have to have one of us do that and say, no, you're the servant, I'm the master. Right? Okay? And this is what I've done. Okay? In Idaho. It doesn't matter where it's at. Reading means reading. You have to know the right. Article 1, Declaration of Rights. Right of assembly. The people shall have the right to assemble in a peaceable manner, to consult for their common good, to instruct their representatives. Just like math, you got to do it backwards to check your work. So let's read this backwards. You petition the legislature for the redress of grievances. Oh. That's how you instruct your representatives. After you peaceably assemble, you assemble them to consult for our common good. And then, oh yeah, that's right. That's how this works. Remember, all political power is inherent in the people. They are the servants. They are the citizens. Start calling them sovereign citizens. Well, you're trying to be a sovereign citizen. We, the people, have all the power. You're the citizen. You're vested with certain sovereignty, the delegation of power. But the powers you have are to sit down, shut up, and do what you're told. When we, the people, the master comes in to petition the legislature for a redress of grievances, you're supposed to sit down, shut up, and do what you're told. Because that's what it means to instruct their representatives. They are the servants. We are the masters. Knowledge is power, folks. It has literally empowered me. And these people want to come at these citizens, public servants want to come at me like this. This is how I talk to them. I put them in their frickin' place. Because I have every right to. You want to talk shit to me? I'm going to put you in your place. Because I have the knowledge. I can cite this stuff off the top of my head. Because I know it. Because I've read it. That's how that works. That's what's meant by knowledge is power. And just like God tells us in the Bible, our tongues are sharper than a double-edged sword. How in the hell are you going to speak this law if you don't know it? It's completely illogical. Plain and simple. You have to know knowledge to speak it. So many people out there talk about, oh, I know my rights. Well, tell me about your rights. Can you cite them? Recite them. Speak it. Well, I know what they are. Well, speak them. Tell me. Tell me what your rights are. Well, then they don't know. Don't come at me telling me you know stuff and you don't, because I'm going to test you. And not because I want to be a jerk. It's because you're coming at me telling me that I don't know what I'm talking about and that you already know. But when it comes to test time, you don't know. I'm here to help you. But you come at me with your arrogance and try to tell me that you know when in fact I know, and I can tell that you don't know because I do know. So, this is one of those things that we're supposed to do. Following due process of law, because this is law of the land or common law of the land. Law of the land literally means due process of law. So, the right of petition. In all tyrannical governments, the supreme magistrate has the right of both making and enforcing the laws vested in one and the same man or one and the same body of men, and wherever these two powers are united together, there can be no public liberty. The magistrate may enact tyrannical laws and execute them in a tyrannical manner, since he is possessed in the quality of dispenser of justice with all the power which he, as legislator, thinks proper to give himself. But where the legislative and executive authority are in distinct hands, the former will take care not to entrust the latter with so large a power as may tend to the subversion of its own independence, and therewith the liberty of the subject. With us, therefore, in England, the supreme power is divided into two branches. The one legislative, to which the Parliament, consisting of the King, Lords, and Commons, the other executive consisting of the king alone. Well, how is that actually two distinct branches of government? It's not. The king is part of both of it. And of course, the supreme and absolute authority of the state is vested by our Constitution. The original or first institution of Parliament is one of those matters which lies so far hidden in the dark ages of antiquity that the tracing of it out is a thing equally difficult and uncertain. The word Parliament itself, colloquium, as some of our historians translate it, is comparatively of the modern date, derived from the French, signifying an assembly that met and conferred together. See? The General Assembly is the legislative branch. Those are elected officials. But it has to come from the Constitution. So again, the people have to assemble first. The body of the people themselves has to be assembled first. It was first applied to the general assemblies of the states under Louis VII in France about the middle of the 12th century. But it is certain that long before the introduction of the Norman language into England, all matters of importance were debated and settled in the great councils of the realm, practice which seems to have been universal among the northern nations, particularly the Germans, and carried by them into all countries of Europe, which they overran at the dissolution of the Roman Empire. Yeah, whatever. Relics of which constitution or various modifications changes are still to be met with in these, the Diets of Poland, Germany, and Sweden, and the Assembly of the Estates of France, for what is there now called the Parliament, is the only supreme court of justice, consisting of the peers, certain dignified ecclesiastics and judges, which neither is in practice nor is supposed to be in theory a general council of the realm. But that's what we did here. The right to petition the legislature for the redress of grievances. Why does it have to do that? I thought I had that saved, but I wonder if it's back up there. Maybe it was 143. Yeah, there's this one part here. Constitution, powers, limitation of king's prerogative. Third, subordinate right of every English is applying to the courts of justice for redress of injuries. Since the law is in England, the supreme arbiter of every man's life, liberty, and property, courts of justice must at all times be open to the subject, and the law be duly administered therein. The emphatical words of Magna Carta, spoken in the person of the king, who in judgment of law, says Sir Edward Kirk, is ever present, and repeating them in all his courts, are these, and therefore every subject continues the same learned author for the injury done to him and any other subject, be he ecclesiastical or temporal, without any exception, may take his remedy by the course of law, due process of law, and have justice and right for the injury done to him freely, without sale, fully without denial, and speedily without delay. That's right. Because justice is to be, and this is part of the Magna Carta, 1215. It were endless to enumerate all the affirmative acts of Parliament wherein justice is directed to be done according to the law of the land. And what that law is every subject knows or may know, if he pleases. For it depends not upon the arbitrary will of any judge, but is permanent, fixed, and unchangeable, unless by authority of Parliament. It shall, however, just mention a few negative statutes whereby abuses, perversions, or delay of justice, especially by the prerogative, are restrained. It is ordained by Magna Carta that no free man shall be outlawed, that is, put out of the protection and benefit of the laws, but according to the law of the land. See, not by statutes. I'm looking for the one part where it talks about if there should happen any uncommon injury or infringement of the rights before mentioned, which the ordinary course of law is too defective to reach, there still remains a fourth subordinate right, appertaining to every individual, namely the right of petitioning the king or either House of Parliament for the redress of grievances. In Russia, we are told that Caesar Peter established a law that no subject might petition the throne till he had been petitioned 2 different ministers of the state. In case he obtained justice from neither, he might then present a 3rd petition to the prince, but upon pain of death if found to be in the wrong. The consequences of which was that no one dared to offer such 3rd petition, and grievances seldom falling under the notice of the sovereign. He had little opportunity to redress them. The restrictions for some there are which are laid upon petitioning in England are of nature extremely different, and while they promote the spirit of peace, they are no check upon that of liberty. Care only must be taken, lest under the pretense of petitioning the subject to be guilty of any riot or tumult, as happened in the opening of the memorable Parliament in 1640. And to prevent this, it is provided by the statute 13 blah 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 blah, that no petition to the king or either House of Parliament for any alteration in church or state shall be signed by above 20 persons, unless the matter therefore be approved by 3 justices of the peace, or the major part of the grand jury, 20, in the country, and in London by the Lord Mayor, Aldermen, and Common Council, nor shall any petition be presented by more than 10 persons at a time. But under these regulations, it is declared by the statute 1 William and Mary, that's the English Bill of Rights, that the subject hath the right to petition, and that all commitments and prosecution for such petitioning are illegal. Then the fifth and last auxiliary right of the subject that I shall at present mention is that of having arms for their defense, suitable to their condition and degree, and such as are allowed by law, which is also declared by the same statute, 1 William and Mary, the English Bill of Rights, 1689, and is indeed a public allowance under due restrictions of the nature of the natural right of resistance and self-preservation, when the sanctions of society and laws are found insufficient to restrain the violence of oppression. This is where, this is where the Supreme Court referenced the right to keep and bear arms come from, the right of self-defense. This is the book. This is it. This is what they cited about speaking on the Second Amendment, that we do not need to seek permission to carry arms, openly or concealed. That's that New York State Rifle Pistol Association versus Bruin case. Done deal. Yep, this is where they cited from. I swear it was right here, but it's talking about the vindication of these rights. But that's the gist of it right there. We got to go to the courts, then petition the legislature, and then we can take up arms. Just like it says there in the Declaration of Independence, we have petitioned in the most humble terms we have this right, folks. Plain and simple. We have to follow due process of law. I swear it was right. Maybe it was after that. Yeah, well, the thing is that's due process of law, folks. We're supposed to go through the courts, right? And then if it doesn't work out in the courts, then we go to the legislature, because the courts didn't uphold their duties. They didn't perform their duties and ensure justice. Okay? Then, if they don't respond to the petition and ensure justice, we've petitioned, we've battled it out in the courts, we've petitioned. What else will we have left to do? These several articles exist of the rights, or as they are frequently termed, the liberties of Englishmen, liberties more generally talked of than thoroughly understood, and yet highly necessary to be perfectly known and considered by every man of rank and property, lest his ignorance of the points whereon they are founded should hurry him into faction and licentiousness on the one hand, or a pusillanimous indifference and criminal submission on the other. And we have seen that these rights consist primarily in the free enjoyment of personal security, of personal liberty, and private property. So long as these remain inviolate, the subject is perfectly free. For every species of compulsive tyranny and oppression must act in opposition to one or other of these rights, having no other object upon which it can possibly be employed. To preserve from violation, it is necessary that the Constitution of Parliament be supported in its full vigor, and limits, certainly known, be set to the royal prerogative. And lastly, to vindicate these rights, there it is, and lastly, to vindicate these rights when actually violated or attacked, the subjects of England are entitled, in the first place, to the regular administration and free course of justice in the courts of law. Next, to the right of petitioning the King and Parliament for redress of grievances. And lastly, to the right of having and using arms for self-preservation and defense. There's due process of law in a short, clear, concise statement of fact. Courts, legislative branch with a petition, and then we take up arms. This is what the Supreme Court's been citing from as a viable source to cite from. Yes, this is Blackstone's Commentaries on the Law of England. This is Book 1, Chapter 1, Section 143. Nope, 144. But I start with 143. I knew it was right here at 143, but 144. So I was right here just a little bit ago. Just didn't read down far enough. So, again, that's it. That's due process of law. You battle it in the courts, you do the petition, and then we take up arms. That's the law as it is written. Not my opinion. Again, if it's good enough for the Supreme Court to cite from as a source of law, don't you think we ought to be reading it? Absolutely. Because in the very beginning part of this, it lays out those three primary absolute rights that are unalterable, unavoidable. That personal security, personal liberty, and private property. So, again, due process of law must be followed. And then, once you get to you've gone through the courts and you're not getting justice, you go to the legislature with a petition in proper form saying, hey, my rights are being violated here by these people over here that you created. You provide oversight. If you fail to provide oversight, that is internal insurrection. That is Article 4, Section 4. Then we go to the legislative branch, Congress, federal, pursuant to Article 4, Section 4. On application of the legislature or the executive, legislature can't be convened. Again, this is Luther versus Borden. This is a political argument, not a judicial one. The judicial branch does not have a say in this. They have no power. And the executive is commander-in-chief, the military. Remember, the military is subordinate to the civil power. But this is where we go back to the Constitution, as it is written. What does it say as it is written? Article 4, Section 4, the United States shall guarantee every state in this union a republican form of government shall protect each of them against invasion, and, on application of the legislature or the executive, when legislature cannot be convened, against domestic violence. Domestic violence is internal insurrection, an attempt to overthrow the Constitution and war against the people. That's what domestic violence is. Internal insurrection. Doesn't have anything to do with domestic relations with family. That's a lie. See, that Violence Against Women Act in 1994, see, this isn't that far back in history that this happened. That they redefined what domestic violence is. And actually, what they've done, Congress, when they created the Violence Against Women Act, this is what we talked about, Chris and I and John. You know, the thing is this is using women and children as human shields. And created the Violence Against Women Act. In part of that, Rules for Radical by Saul Alinsky, to destroy the family unit. They're using the women and children against the men to destroy the family unit, saying, oh, well, you can just go in and get this domestic violence protection order without ever filing any criminal charges, never following due process of law, having a grand jury indictment, all that good fancy stuff that the law of the land and the common law dictates that is supposed to happen. Because yes, you can get an order of protection through the criminal process. Criminal process. But again, that's what they done. Let's go into this historical background on the Republican form of government under Article 4, Section 4. Article 4, Section 4 is generally known as the Guarantee Clause. Through its terms, the United States makes three related assurances to the states: a guarantee of Republican form of government, protection against foreign invasion, and upon request by the state, protection against internal insurrection or rebellion. But it's not about rebellion, it's about internal insurrection, because that's what domestic violence is, not rebellion. That's a lie. But let's see what that says. Oh, Federalist number 21, Hamilton. An earlier version of the Guarantee Clause was among the resolutions of the Virginia Plan introduced in the Constitutional Convention by Edmund Randolph and attributed to James Madison. Wonder what that one was. No reference to Federalist. Oh, writings of James Madison, 336. Second writings. The resolution went through several formally initiation. Here it is. To secure Republican government, to suppress domestic commotions, along with concerns about rebellions, delegates expressed fears that a monarchy might arise in a particular state and establish a tyranny over the whole United States. That's what that's about. And that's what's happened again. Answering Morrison's objection, Madison moved to substitute the language that the constitutional authority of the state shall be guaranteed to them respectively against domestic as well as foreign violence. With Randolph then moving to add the language that no state shall be at liberty to form any other than a republican government. James Wilson then introduced as a better expression that a language substantially similar to the final form of the Guarantee Clause, which convention approved unanimously. In light of the text and framing, the Guarantee Clause was intended to be more than an authorization of the federal government to protect states against foreign invasion or internal insurrection, a power already conferred elsewhere in the Constitution. While the precise contours of what constitutes a Republican form of government are debatable, an additional object of the Guaranteeing Clause is to prevent states from establishing a monarchical or despotic governments. Can't be any more clear than that. Even though it talks about in other parts, they say in other parts, but this is due process of law. on application of the legislatures. Okay? But this is where you go, okay, you do the petition to Congress, and then what are they supposed to do? Huh. To provide for calling forth the militia to execute the laws of the Union, suppress insurrection, and repel invasions. Holy crap, it's right there in the power of Congress to provide for calling forth the militia to execute the laws of the Union to suppress insurrections. Due process of law. And who has what powers? That's how this works. Yeah, internal insurrection versus rebellion. Thank you, Diesel Dees. Because rebellion is rebelling against lawful authority, and that's the people or rebels, rebellions, right? When we're talking about internal insurrection, again, that's the public servants. That's that maladministration, malfeasance, misfeasance, denying justice. When we follow due process of law, we go to court, we battle it out, the judge denies, denies. Then you go to the legislature to provide oversight, because the legislature does the investigation to see if the judge has exceeded his authority, which is grounds for impeachment, removal from duty. And then you strip him of his immunity from being sued through the impeachment process in the legislative branch, because that's the process that is due to the magistrates, to the judges. Okay? Then you can sue them in their individual capacity because they have been stripped of their immunity. That's what that does. Okay? So, that's that internal. Then when the legislature doesn't perform their duties, they do not impeach that judge. They do not remove him from duty. They do not ensure justice. Because we, the people, establish justice. They're the ones that we're supposed to demand it from. Otherwise, that's when we take up arms. But you go from state legislature to Article 4, Section 4, and go to Congress. And if Congress does not assemble, this automatically goes to the executive branch, which is Commander-in-Chief. Which is why we are where we are at today. Executive Order 13818. That is where we are at. We need to tell on them. Again, internal insurrection is an attempt to overthrow the Constitution, the laws of their creation, and war against the people. That is tyranny, despotism. But we cannot claim that we are under absolute despotism unless we follow due process of law. You battle it out in the courts, then you go to the legislative branch. If the state legislature doesn't do their job, then that's internal insurrection. They're not performing their duties. They're not ensuring justice here. Then you got to go to Congress. And if Congress doesn't do its job, then you got to go to the executive, Commander-in-Chief, the military, and instruct the military to do their job. If not, they don't do it, then we have the right to take up arms. in that order of process. Due process of law. Law of the land. What we just read from is the supreme law of the land. Supreme due process of law. Not code. No statutes here. This is all law. Nowhere did I cite any statutes here. This is all straight from the Constitution. Declaration of Independence. Declarations. Laying down the law. Did anybody take notice of that? None of this is code. None of this is statutes. All straight from law. You're right, Cece. Out on Facebook. No one is doing their job. Including the people. The people aren't doing their job. They're derelict in their duties to follow due process of law. Put the blame where it belongs. On the people directly. Plain and simple. Oh, Mark Vaughn, I'm glad somebody said it. Sounds like the chain of command. Absolutely. All right, folks. I hope that I planted some seeds. And I hope and pray the people study, learn, do it. Like I am. Like I have done. Like I have been doing. And it's coming. Big stuff is coming, I'm telling you. Writing's on the wall. Executive orders. Well, you want to get rid of the crooked idiots, you have to learn how to tell on them. Follow due process of law. There is no other way to do this. Okay? If we don't do this, then who? If all political power is inherent in the people, and the people decide, well, I'm just done. I ain't doing nothing. You get what you get. And I'm tired of hearing that. Am I the only man out here on the face of this planet that wants to do something here about this? I can't do this by myself. Like I said there earlier, have to have a majority of the people. That's right. We gotta round up the people. No, we're not under common law. We're supposed to be. We're under Roman civil law, the code. You know, United States Code, Idaho Code, Code of Federal Regulations, Uniform Commercial Code is Roman civil law. We're not under common law. We're under Roman civil law. Back under the monarchy. That's internal insurrection. That's domestic violence. That violates Article 4, Section 4. Maybe you ought to follow due process of law and do something about it. All right, folks. Here's my website, kirkslawcorner.com. On the main homepage here, I got links: Facebook, Telegram, Patreon, YouTube, Rumble, and X. I do a lot of stuff on my Telegram channel. pretty much primarily everything I do is through my Telegram channel. I do the lives through Facebook. I do post some stuff on my Facebook page. Videos are stored on there, of course. YouTube as well. But posting wise, I do through Telegram. Those who'd like to support is through Patreon, Tier 1, Tier 2. It's like buying me a cup of coffee a month, right? Tier 1 is $5 a month. Tier 2 is $10 a month. That's how you can support me in what I'm doing, what I'm working on, everything else that's going on. If you'd like to get on Wednesday night workshop, that's where I start going in depth and teaching other things about paperwork and what I've done, how I've done it, how I've been successful. Other private type stuff goes on through Wednesday night workshops. Now, if you're looking for help, you want my individual time, talk about your personal case, that is Tier 4, one-on-ones. Okay? Other than that, for those who'd like to just send regular donations, however you want to do that, through postal money orders, cashier's checks, regular checks, cash wrapped in aluminum foil, gold, silver coinage, any law books type stuff, send that over to me at the office. Kirk Pendergrass at 6477 West Fairview Avenue, Suite G, Boise, Idaho, 83704. That is golf. Okay. So, do a quick shout out to Miles, who did this website for me, who helps maintain all of this, pays for this. If you want somebody to help do your website, you can click on that right here. Website by Miles at divina.website. Want to thank those that recently donated, and of course, again, I have to show these off here. The Blackstone's Commentaries on the Law of England. Thank you, Jack. Says my birthday. And again, happy birthday to Jax as well. And I don't see Snow Tiger on here tonight. Her birthday was the 16th. So, round of happy birthdays for all those here in July. But, again, had a good time on my birthday. Now, about the people. Reassembling the people. Common law. We have this conference call, weekly conference call, Thursday night. The first part's the business side, so try to keep yourself muted when you join. And again, I highly recommend downloading and installing the app. Free conference call app. It's free. It's so much easier to use the app, whether you're on your smartphone or on your desktop, laptop, anything like that. Okay? There's two videos here on YouTube. Here's links to those. One for how to do it on smartphones, the other how to do it on your desktop. I have it on both. I have it on my phone and my desktop. And then this is the link to join the call. Once you do this the first time in your app, it'll save it in there. So all you got to do is go right back to that. You don't even have to come back here to click on it. The link will be stored in your app. Okay? And that's 6 p.m. Pacific, 7 p.m. Mountain, 8 p.m. Central, 9 p.m. Eastern. Okay, usually goes for about 2 hours, 7 my time, 7 to 9, 9 to 11 Eastern. So I get that's kind of late for you Eastern folks, but this is how we're coming together. Getting connected. All right. So this is the website, national-assembly.net. Again, national-assembly.net. That is the website. Then you can get into your forums and blogs, National Assembly forums, and go down to your state. There it is. The 50 nation states. Find your state. Get in that general introduction. Get in the introductions, general chat. Well, nobody's posted in Idaho since then. But this is how we're coming together, folks. And if you're looking to get in contact with your coordinator, moderator, or anything else, Content Manager 1, the number 1, at yahoo.com. Okay? Thank you all for tuning in tonight. Hope we learned something tonight. It's a pretty big deal, folks. Needs to be taken seriously. So, again, just want to show these off now with full screen. Will it let me? There it is. That's volume 1. They actually broke these down into 4 different volumes instead of two volumes and 4 books. 2 books, but 2 volumes, including the 4 books. But yeah, these are 4 separate volumes and really nice condition. So thank you again, Jax. It's again just so crazy to me that I used to hate to read in school, and yet here I am, a reading frickin' fool. Yeah, kind of ecstatic. Never thought I'd ever be ecstatic about receiving books and reading books, but here I am. Things change, right? So, that book there is from the PDF that I was just reading from tonight. So, yeah, reading means reading, folks. You must read. Knowledge is power. If you don't have the power, how are you going to wield it? All right. Have a wonderful night, folks. Thank you all for being here. God bless. Pray for the world, people, the people. Again, all political power is inherent in the people, not state nationals. The people. All right? Remember that. God bless America. God bless the world. But God bless the people. We got to do this, folks. It's got to be us, the people. We have to reassemble the people. There is no other options. Okay? Trust me, I've looked, I've researched, I've studied since 1995. In the end, the people need to reassemble. That is the solution. In the end. Because all political power is inherent in the people. Without the people coming together, how are we going to alter, reform, or abolish anything? You don't have the people. We get what we get. So, think about what you're leaving your kids and your grandkids. All right. Have a wonderful night, folks. We'll see you. Wednesday night workshop will be happening this week. Have a wonderful, we'll have a nice little meeting there Wednesday night. And then, of course, Thursday night, the National Assembly call. And then we'll see everybody else back here on Monday night for Monday Night